It should be overruled for 3 reasons. First, Chevron violates the Constitution. Article 3 empowers judges to say what the law is. It requires them to interpret federal statutes using their best and independent judgment. Chevron undermines that duty. It reallocates interpretive authority from courts to agencies, and it forces courts to adopt inferior agency constructions that are issued for political or policy reasons. In doing so, Chevron blocks judges from serving as faithful agents of Congress. It mandates judicial bias and encourages agency overreach. And by removing key checks on executive power, it threatens individual liberty. Chevron also violates the APA. The most straightforward reading of Section 706 requires de novo review of legal questions. Congress put constitutional and statutory interpretation on equal footing, and it required independent legal judgment as to both. As Justice Scalia wrote, the APA's text contemplates that courts, not agencies, will authoritatively resolve ambiguities in statutes. And third, this Court's only justification for Chevron is the implied delegation theory, but that theory is a fiction. There's no reason to think that Congress intends every ambiguity in every agency statute to give agencies an ongoing power to interpret and reinterpret federal law in ways that override its best meaning. In this case, the agency misinterpreted the MSA to force struggling fishermen to pay up to 20% of their annual profits to federal agents. The government says that even if all 9 of you agree with us that the agency's construction is worse than ours, you should nonetheless defer to that construction and uphold their program under Chevron. That's not consistent with the rule of law. If we have the best view of the statute, we should win this case. I welcome the Court's questions.
Mr. Martinez, how much deference is in tension with the judicial role?
I think it's very much in tension, Your Honor.
How much would it require? I mean, your argument is that Chevron deference is problematic, but how do we determine how much deference is too much deference?
I think you've certainly crossed the line when you have a rule that says that we're going to allocate interpretive authority from Article 3 courts to an agency. And so when you've got deference that amounts to that, which is what Chevron deference is, then I think you've crossed the line. Because what you've really done is...
What I'm asking is, how do we know where the line is? We show deference. There's Skidmore deference.
Sure.
We are deferential in fact-finding, et cetera. So I'm just trying to determine whether you're saying that if it's not de novo review,
right,
without any presumptions or deference, then it's problematic.
I think deference becomes problematic when it requires a judge to say that the law means X, when really the judge thinks the law means Y. I think Skidmore deference is not problematic because it doesn't require that. Skidmore deference essentially says, and we would be very comfortable with Skidmore, that because the agency has an important role to play in the process, often the agency has helped draft the statute, the agency has knowledge of the policy context surrounding the statute and its implementation. Of course, courts should pay special attention to what agencies say, but the agency ultimately has to bring its expertise to bear in a way that's persuasive. And if the court isn't persuasive, if the court thinks that the law means X even though the agency thinks the law means Y, then the court needs to go with the best interpretation of the statute, just like it does in every other area of statutory or constitutional interpretation.
Let's suppose the statute says the Department of Transportation will set length limits for trucks that are reasonable.
Right.
Is that a legal question for the court, or is that a policy question for the agency?
I think that
the legal authority says they've got to be reasonable. That's a term that courts apply in many situations.
I think that a court looking at that statute would try to determine the best meaning of the statute, and the best meaning of the statute there would be that the use of the term reasonable confers upon the agency discretion to choose among certain policy options. Now, that doesn't mean that the agency can just do whatever it wants, because there are limits, and the court has to police that limits. Michigan versus EPA is a good example. Congress used a broad term like appropriate, and the question was, which is similar to reasonable, in giving the agency a range of discretion. But at the same time, when the agency said, well, we don't have to consider costs in figuring out whether something is appropriate, the court said, no, that as a legal matter, the best interpretation of the word appropriate in the context of this statute requires the agency to consider
Well, what if
cost.
the statute says that the agency can regulate truck length for vehicles that travel in interstate commerce? And there's a question whether or not the delegation for interstate commerce is satisfied when particular circumstances are present.
I think that would be a case if the court were called upon to interpret if the dispute was about what interstate commerce means. I think that would be a classic legal question. That would be a legal question for the court. And I think it actually highlights, because interstate commerce is probably there because of the constitutional limitations, it highlights the fact that really the same rules should apply to interpreting constitutional provisions as statutes.
You can imagine situations where the interstate commerce determination is peculiarly fact-bound. You know, trucks transferring loads at transfer points on the border. Is that in interstate commerce for each one or not? And isn't the policy judgment of the agency pertinent in that situation?
I think certainly the policy judgment of the agency is pertinent in determining sort of the facts, because the agency might be on the ground and understand the factual scenario. But I think there's an important legal component to that question that in any other context, like, for example, if you were interpreting the Constitution, I think the court would quite reasonably think it's its own job to interpret the constitutional requirement of interstate commerce and would give its best meaning.
Well, let me give you a few more examples along the same lines, Mr. Martinez. Is a new product designed to promote healthy cholesterol levels a dietary supplement or a drug?
Sorry, can you give that one more time?
A new product designed to promote healthy cholesterol levels. Is it a dietary supplement, that's a statutory term, or a drug?
I think it would depend on the original understanding of the text of that statute read in context. I think that's a legal question for a court.
You think that the court should determine whether this new product is a dietary supplement or a drug without giving deference to the agency, where it is not clear from the text of the statute or from using any traditional methods of statutory interpretation whether, in fact, the new product is a dietary supplement or a drug. You want the courts to decide that?
Justice Kagan, I think with respect to that question or any other of a legal question, I think what the court would do, they're going to be hard questions, but I think the court would bring all the traditional tools of construction to bear.
They do that under Chevron. We have made clear all the traditional tools. If you can find an answer, that is the answer. So the court is very rarely in the situation in which you're talking where it thinks the law means X and instead it says Y. If it thinks it means X under Chevron, as we've understood it and made clear and reined it in a little bit over these last few years, it's supposed to say X. But sometimes law runs out. Sometimes there's a gap. Sometimes there's a genuine ambiguity. And I don't know. In that case, I would rather have people at HHS telling me whether this new product was a dietary supplement or a drug.
So, Your Honor, I think a couple things. First of all, I don't think Chevron is a doctrine that only applies to tiebreaker 50-50 scenarios. It's never been understood that way. Justice Scalia, in his famous article in 1989...
It's not a tiebreaker. There are just some times where you look at a statute and the most honest reading is that there's a gap there because of the limits of language, because of the limits of our ability to predict the future. And so who fills that gap?
But I guess what I would sort of push back on is I don't think there's a gap if the court looks at the statute and thinks, hey, this is a really hard case, it's a really close statute, 52% likely, I think, I have 52% confidence that X is right, 48%
I'll give you another one, Mr. Martinez. Does the term power production, these are real cases.
Right.
These are prototypical Chevron cases.
But,
does the term power production capacity refer to AC power that is sent out to the electric grid or DC power that's produced by a solar panel?
I think same answer as the first hypothetical, but let me try to sort of give you a different framework for thinking about this problem. Let's imagine that statute came to a court before an agency had even acted in the first place. What would a court do? Would a court look at a statutory term like that presents a hard interpretive question and say, well, this is hard, it's sort of 52-48, it's kind of close, I think the law has run out and I'm just not going to be able to decide this? I think the court would go with the best interpretation.
The court in that case would have to make a choice, but you see here the court can say the best option is to listen carefully and to defer, if it's reasonable and if it's consistent with everything that we know that Congress has said, to defer to people who actually know things about these things, to people who understand the way particular questions fit within a broader statutory and regulatory scheme, to people who have understanding of the policies and of the facts that led to this. I'll give you a third example. This will be my last one, Mr. Martinez, and it's going to be my fairest one, because it's going to be one you know about, which is Chevron. Is a stationary source in the Clean Air Act. Does it refer to whole plants or to each pollution-emitting device within the plant?
We think that the decision in Chevron reflected the best interpretation. With much respect to Justice Gorsuch's mother's EPA, we think that was the best interpretation. But can I just go back and I think what you described earlier about listening to the agency and taking into account all those things, our rule would allow that. That's Skidmore. I think the only difference between our rule and the Skidmore sort of approach and the Chevron approach is that after listening to the agency's explanation of all the things that you said, if the court isn't persuaded by the agency that the agency's interpretation is correct, Chevron would say you still have to go with the agency. And that's just like a dramatic thing.
But why not? Meaning, I think all of the play in disagreement is around the word ambiguity. I know that there have been some earlier cases that suggested if there were two plausible meanings, you went with the agency meaning. I think we've gone far beyond that. It has to be two reasonable meanings. Assuming you make an assumption that there is a best answer. I don't know how you can say there's a best answer when justices of this court routinely disagree. And we routinely disagree at 5-4. Is the best answer simply a majority answer? I don't think so.
But, Your Honor,
I happen, when I dissent, to think the others got it wrong. And they often do. But putting that aside, in those situations, there are two plausible, not merely plausible, there are two best answers. And the question is who makes the choice or helps you make the choice. And if the court can disagree reasonably and comes to that tiebreaker point, and it could be 51-49, it could be 52-53, if it's that close, why shouldn't the person with all of the qualities you spoke about, the entity with all of the qualities, expertise, experience, on the ground execution, knowledge of consequences, why shouldn't deference be given to that entity?
Justice Sotomayor, I think your explanation of ambiguity just now just proves the problem with Chevron. Because I think what you said is that whenever there's a case, a statutory case in which the members of the court disagree with one another, that's essentially saying the statute's ambiguous because reasonable people can disagree.
But that's what nobody believes about Chevron, Mr. Martinez. As we've described it, is you work hard to figure out a statutory problem. You don't say, oh, it's difficult, oh, there are two interpretations, oh, not everybody agrees with this in 3 seconds flat. You don't say that. You do everything you do. Look at the text. Look at legislative history if you believe in legislative history. Look at context. Look at every tool you can. And still there are places where we don't know whether this drug whether this product is a drug or a dietary supplement. And it's best to defer to people who do know, who have had long experience on the ground, who have seen 1,000 of these kinds of situations. And, judges should know what they don't know.
I agree with that, Justice Kagan, but with all due respect, I think I understood Justice Sotomayor to be saying that whenever justices of this court disagree about the best meaning of the statute, because obviously everyone on the court is reasonable, that shows that there's an ambiguity. If that's the test, which I think was the implication of the question, then that can't be wrong. That's much broader than
That wasn't my
step one.
implication. My implication was that using all the statutory tools, you can still come up. Using them in good faith, using them, you can still come up with no answer, with no clear answer.
I think you can come up with no clear answer.
Or no best answer.
Because some statutes are hard, but I think you can come up with the best answer. And the reason I think that is
best only because a majority agrees.
But no, because if you had the same statute with the same interpretive question posed to you without the agency having acted, I don't think you would say there's no answer here. I think you would choose the best answer.
But Mr. Martinez, I guess I'm struggling to understand what's at stake here, given the questions, because as I understand Justice Kagan's hypotheticals, which are hard ones, that one option would be to say it's ambiguous and therefore the agency always wins. That's what I understood Chevron to mean, at least coming in here today. Another would be to listen carefully to both sides and provide special weight under Skidmore to a co-equal branch of government's views about the law, which one would think we would do anyway, and that they would be considered great weight in arriving at the best answer, and that's what a court would do if there were no interpretive principles advanced by the executive branch, if there hadn't been some sort of rule or adjudication. Is that correct?
I think that's correct, and I think the difference between the Skidmore approach that you just laid out and the Chevron approach is just at the end of the day, once you've considered all the expertise and all the information the agency has to bear.
Who decides?
Who decides? Is the judge persuaded or not persuaded?
Is the judge persuaded at the end of the day with proper deference given to a co-equal branch of government, or does the judge abdicate that responsibility and say automatically whatever the agency says wins?
Right, even if the judge is not persuaded.
But Mr. Martinez, doesn't that...
If I might just finish up. What's the effective difference of that? It seems to me that in the first case, when a judge says, here's the law, it's settled. We're done, right? It can be appealed, but at the end of the day, if the Supreme Court of the United States upholds that interpretation, we're finished. Whereas under the Chevron approach, are we finished?
No.
What happens?
I think the agency can overrule what the court said. The agency can overrule what itself said. I think that's a very strange thing, that in every other area of statutory interpretation, we understand the law to have one fixed meaning, and the goal is to try to figure out that fixed meaning. But Chevron, by design, creates this world in which the agency is because there's this zone of discretion, the agency in ambiguity, the agency can kind of flip-flop and then force courts to flip-flop with that.
And I'm struck on that score by the Brand X case, which involved broadband, in which this court said, okay, agency, you automatically win with respect to one interpretation in the Bush administration, I believe it was. And then, of course, the next administration came back and proposed an opposite rule.
Right.
And then the next administration came back and flipped it back closer to the first. And as I understand it, the present administration is thinking about going back to where
That's exactly right. That's exactly right, Justice Gorsuch, and I think it plays up the real problem. Chevron really is a reliance-destroying doctrine. Imagine if you're a person or a regulated entity and you're trying to figure out what the law is. You should be able to rely on the best interpretation of the law and not have to, check the CFR every couple of years to see if the law has somehow changed, even though Congress hasn't acted.
And that's the delta between Skidmore and Chevron.
I think that's right. I mean, Skidmore, I think, would allow for courts to give meaningful weight and consideration to persuasive opinions by agencies. The only thing Skidmore doesn't do is require a court to give up its ultimate interpretive say and defer to an interpretation that is not persuasive.
Mr. Martinez, what I'm stuck on is what seems to be an assumption in your argument that every question posed with respect to interpreting a statute is a legal one. I see Chevron as doing the very important work of helping courts stay away from policy making. And so I'd like for you to sort of think of it through that lens and help me understand why, if we do away with Chevron's framework, we won't have a problem of courts actually making a policy decision. So Justice Kagan gave you a number of examples, and I think the reason why those examples are hard or why they're ambiguous or whatever is because at bottom, they're not asking legal questions. They're asking policy questions. How is it that stationary source is to be defined? That's not really a legal question. I mean, there could be several reasonable ways of interpreting that. And at the end of the day, I think the way I've been thinking about Chevron is Congress has given that policy choice to the agency. And my concern is that if we take away something like Chevron, the court will then suddenly become a policymaker by majority rule or not, making policy determinations. So how can we avoid that?
So we agree, obviously, that courts should not be in the business of policymaking. And I think the whole enterprise of statutory interpretation, when properly understood, is designed to take courts out of policymaking, because what the court is trying to do is act as a faithful agent of what Congress has done and find the best interpretation.
But isn't that what Chevron does? I mean, isn't Chevron step one, even in this very case, asking the question, one, has Congress made that policy determination? So, for example, here, the question is whether or not monitors on the boats have to be paid for by the owner of the boat. I see that as a policy question. Congress could have said yes or no. There's nothing about law really inherently in the question of should the monitors on the boats be paid for by the owners or the government. So step one is, has Congress in the statute answered that question? When we say no, everybody agrees that's not in the statute, then we say the agency can make that determination so long as they do so in a reasonable way. And the courts sort of police the boundaries of reasonableness, but whether or not the monitors are paid for is not really a legal question.
I think the question of whether or not the law allows the agency to force the monitors to be paid for by private industry is absolutely a legal question. I agree with you that.
But isn't that the same question as to whether or not, isn't that just another way of saying, can this policy determination be made by the agency?
No, I don't think so. I think the difference is when the policymaker, whether it's Congress or the agency, is sitting there and trying to figure out like what the best policy is, would the world be a better place if industry has to pay for these monitors or not? That's absolutely a policy question.
Okay, so that's the question, right?
But no, because when it comes to a court, the court is not figuring out what the best thing for the world is. The court is figuring out, well, what did Congress actually want here?
But I guess I'm afraid that the court really is figuring out what the best thing in the world is if we look at it through your lens, right? Because if the answer to the question is, you know, should they pay for it or not, the agency has a view, and unless we're deferring to that view, I don't see why we aren't overriding the agency's policy prerogative.
The question that the court should be answering is not should industry pay for the monitors. The question that the court should be answering is, did Congress require or allow industry to be forced to pay for the monitors? And that's a very different question. That's the difference between law and policy making. And I think the whole assumption, the whole understanding of statutory interpretation under this court's cases is there's a difference between law and policy making. Judges are there not to exercise force or will. They're there to exercise judgment. They're serving as neutral umpires. They're not players on the field.
All right, so how does that play out under your interpretation? So here, what is the question we're supposed to be answering?
The question you're supposed to be answering is, does this statute require, has Congress either required the monitors to be paid for by industry, or has it given the agency the authority to make that decision? And I think that is both of those versions of that question are legal questions, and the answer is no.
Mr. Martinez, can I ask you a question about this line between law and policy? And I want to ask you in the context of one of Justice Kagan's examples, the dietary supplement or drug. Where is the line between something that would be then subject to arbitrary and capricious review and something that's a question of law? Because I'm just wondering whether we could say that the definition of dietary supplement or drug might be something that's a question of statutory interpretation in the context of the statute, but which category any one thing fell in might be a question of policy for the agency.
Right.
Is that possible?
I think that's right. I think that would be more of a application of law to fact or a factual question. But I think the core question of what is the meaning of dietary supplement, and I forget what the other alternative was, those are legal questions.
But whether the particular cholesterol-reducing drug fell in one category or the other, I mean, presumably that depends on how does this function? What is the mechanism by which it decreases cholesterol?
I think that's right. But I do think it is important to retain the sort of legal component of that question and make sure that the courts have authority over that legal component.
I want to ask you something about your Article 3 argument, too. Justice Thomas asked you what the line is, and, courts all of the time make judgments about whether things are reasonable. But I don't understand you to be disagreeing that things like whether something is, that an agency could be tasked with deciding what was the most feasible, most useful, most reasonable. Well, courts could do that too. So is that a delegation of judicial power that would offend Article 3 in your view to give those kinds of
No, I think the way to think about those kinds of statutory provisions would be that the best interpretation of the statute, given the nature of the word reasonable in context, is to confer a range of discretion on the agency. And so I think a court in that case, if the agency is operating within the range of discretion, that's arbitrary and capricious review. If the agency is sort of operating at the edges, you have to figure out where the guardrails are. That's the legal question. So if the statute says, the agency can pick red, blue, or green, then the choice among those three options is for the agency. But if you have a legal question like, oh, does pink count as red, that's a legal question.
Thank you, Mr. Martinez. How much of an actual question on the ground is this? I saw some study that said we haven't relied on Chevron for 14 years. And Judge Kethledge has written, he's been a judge for 10 years. He's never invoked Chevron Step 2. Judges are used to deciding things, and when they get around to doing it, they tend to think what they've come up with is not only the best answer, but it's the only answer. And I just wonder how often this comes up.
I think it comes up a lot, Your Honor, and this court hasn't relied on Chevron since 2016, but the lower courts still have to apply it. And I think these two cases, the two that you're going to hear this morning, sort of show what happens when courts are applying this doctrine, because they're essentially getting to a point where they don't really have to figure out the best answer. And they can just, instead of asking what does this statute mean, they can ask a different threshold question, which is this statute ambiguous enough that we should just, let the agency do the work for us?
Thank you, Justice Thomas. Justice Alito?
Mr. Martinez, would you agree that one of the reasons why Chevron was originally so popular was concern that judges were allowing their policy views, consciously or unconsciously, to influence their interpretation of the statutes in question?
Yes.
Why was that fear unfounded? Why do you think now that the fear was unfounded?
Well, I think three things. First of all, I think the fear it's reasonable to think the fear has diminished over time, regardless of what it was then, in large part due to the very salutary developments in the way that this court and the lower courts generally now think about statutory construction. In the old days, there was a lot of reliance on legislative history and on sort of more free-form analysis that I think made it easier for policy considerations to infect the judicial decision-making process. But this court has now made clear that, really we should be text-focused. We should be focused on faithful agency to Congress. So I think that is one difference. I think another difference is courts now have become more appreciative of the fact that we're not just talking about, rules of like judicially made common law about how to interpret statutes. We have the APA here. Justice Scalia was a big defender of Chevron in its original incarnation, but over time came to realize that the APA had text that actually bore on this question. And I think when you're enforcing that text, you come to the same place as our Article 3 argument, which is that courts have to exercise independent judgment.
Do you think that the canons of interpretation that we have now and all of the other tools that we have in our statutory interpretation toolkit are like the Enigma machine, and so we have these statutes and they're sort of written in code and we run them through the Enigma machine and abracadabra, we have the best interpretation? Do you really think that's how it works?
I think that what this court does with respect to the normal canons of construction is it's generated those canons as rough rules of thumb to help guide the interpretive process, because the court believes that the canons best approximate the best original meaning of the statute, especially, and then there's some canons that sort of are not purely textual canons, but that sort of are informed by foundational constitutional values. I think Chevron's very different from that, because with Chevron, you're doing something, you're not trying to find the best interpretation anymore. You're in fact agreeing that you have to impose the not best interpretation because you have to defer. And so unlike all the other canons, Chevron's the only one that says to courts, you can stop doing your normal interpretive function, and we're going to allocate that interpretive function outside of Article 3.
Thank you.
Justice Sotomayor?
The Solicitor General or someone has given us a list of 77 cases in which the court has used the Chevron approach and interpreted what the law was. Your overruling Chevron puts a question to all those 77 cases.
No, Your Honor. I think
your out is it's stare decisis now?
Right. So
until the agency does something else. And then people can come back because it's not stare decisis anymore.
So I think with respect to the effects of applying normal rules of construction here instead of Chevron, I'd say two things. First of all, the 70 holdings or whatever, the bottom line holdings in those cases would get stare decisis, so they would not be undermined. So there's no convulsive change of the law with respect to this.
I don't understand how that happens. Once you have a new approach, I'm not sure. But let me move on to the second part of my question, which is the cases that come to the court are usually the hard cases. So you say in the last 14 years we've barely referenced Chevron. And do you know what the breakup is? How often have we been consistently upheld the agency in those cases?
In the cases since 2016?
Yes.
I don't know the track record on that, Your Honor.
I know. It's interesting.
But I will say, there's some prominent...
Putting that aside, where we've disagreed, do you suggest that our disagreement was based on ignoring of Chevron or us doing exactly what you say we should be doing, which is to say this is outside the bounds of reasonableness or around the guardrails because you're going outside of plausible, reasonable interpretation?
I think the court in cases like the American Hospital case or the Digital Realty case, which I think are two really good recent examples, the court unanimously overturns the lower court decision because it does exactly the right thing. It does all the canons at step one, and it essentially says, like, the statute is clear. But I think what those 9-0 decisions show is how confusing and unworkable Chevron is, because the lower courts, purported to do or didn't really do what they were supposed to do, and they came to the opposite conclusion, not necessarily because they thought that your interpretation wasn't the best, but rather because it thought that the statute was ambiguous enough that it required deference. And so it was this threshold.
That judgment is inherent in every question. I mean, that kind of problem is just a part, not just of judging, but of decision-making period of life. And so it's not clear to me that the fact that there may be some ambiguity about how much ambiguity, the question that Justice Thomas asked, it doesn't take away from the basic premise of Chevron, which is a reasonable interpretation within the bounds of common statutory interpretation should be given deference.
Right, but I do think the ambiguity trigger introduces a whole kind of threshold question that's very hard to apply neutrally. I mean, you have great judges. Judge Kethledge, I think, was referenced. He's never found a case that required him to go past step one. Judge Silberman, another great judge, said that in most cases he thought the statute was ambiguous. And if there's that much disagreement, then I think that's a sign that Chevron really isn't workable. And this court has tried to rein in Chevron in numerous ways. But I think that what all of those efforts show is that you kind of need a secret decoder ring to figure out what the law means under this court's approach. You have to do step 0. You have to apply Mead. Then you have to do a robust step 1 inquiry, taking into account footnote 9 and taking into account how much ambiguity is needed. In the D.C. Circuit, you have to do step 1.5, where you have to figure out whether the agency recognized that the statute was ambiguous. Under Kaiser, there's maybe a step 3 that says you turn off deference when the agency's operating outside of its area of expertise, and then overlying all that, you've got the major questions doctrine. And so I think if
well,
that's kind
the
of
court's creation.
Right, but it's the court's creation because it's trying to solve the fundamental problem, which is that Chevron is doing something very weird. It's taking interpretive authority that belongs to courts, and it's giving it to agencies. So all of these bells and whistles are efforts to kind of claw it back to address the symptoms, but I think it's time for the court to address the disease, the underlying problem, which is Chevron itself.
Justice Kagan?
Ms. Martinez, I want you to think of this from Congress's perspective. So I was thinking, what is the next big piece of legislation on the horizon? And who knows? Don't have a crystal ball. But I'm going to say, I'm going to guess that it's artificial intelligence. So let's imagine Congress enacts an artificial intelligence bill. and it has all kinds of delegations. Maybe it creates an agency for the purpose, or maybe it uses existing agencies, and it has all kinds of delegations to that agency or agencies about how to regulate artificial intelligence so that this nation can capture the opportunities but also meet the challenges of that. And then just by the nature of things, and especially the nature of the subject, there are going to be all kinds of places where, although there's not an explicit delegation, Congress has in effect left a gap. It has created an ambiguity. And what Congress is thinking is, do we want courts to fill that gap, or do we want an agency to fill that gap? When the normal techniques of legal interpretation have run out, on the matter of artificial intelligence, what does Congress want, Mr. Martinez?
I think Congress wants courts to interpret the best interpretation of their
Congress
apply the
doesn't
best
know what that
interpretation.
answer means. Congress knows that there are going to be gaps because Congress can hardly see a week in the future with respect to this subject, let alone a year or a decade in the future. And Congress knows that there are going to be things that it writes that it's just not going to be clear how this will apply or what it will mean with respect to countless factual situations that this country will have to address. Does the Congress want this court to decide those questions, policy-leading questions of artificial intelligence?
I don't think Congress wants the court to do policy. I think Congress wants the court to do its ordinary function, which is interpret the law and apply the best understanding of the law. And I think the implication of your question is that this is some sort of intentional delegation by Congress. The Chevron deference is this implicit delegation, but I don't think that's right. I think many people, including a very insightful article that you wrote 20 years ago, make clear that this is fictional. This is delegation.
Fictional just means is like academic speak for presumed. We are indeed presuming congressional intent. The congressional intent is, the delegation is not explicit on the face of the statute, but what we're thinking is Congress knows things about different institutions, about what they know, about what they're competent with respect to, and Congress knows that this court and lower courts are not competent with respect to deciding all the questions about AI that are going to come up in the future. And what Congress wants, we presume, is for people who actually know about AI to decide those questions. And also those same people who know about AI are people who, to some degree, in some way, are accountable to the political process. They have constituencies. They have fact-finding abilities. They are obligated to go consult with people. They report to a president who needs to be elected. In all kinds of ways, both with respect to expertise and with respect to their connections to the public and to other policy-making entities, those are the people Congress wants to decide questions about AI. We don't even know what the questions are about AI, let alone the answers to them, we being the court.
Justice Kagan, I think if we're trying to figure out what the reasonable thing to infer that Congress has presumed, I think the far more reasonable presumption, and the one that's most consistent with our constitutional structure, is that Congress is going to presume that courts are going to do law, not policy. They're going to pick the best interpretation and enforce the best interpretation as to this statute in the exact same way that they would do it with respect to any other statute. And I think this case actually, AI is a trickier example. But think about this case.
It's a real example. I mean, this case, whether it was a correct interpretation or not a correct interpretation of Chevron is really not the issue that we're deciding here. The issue we're deciding here is more like that. It's more like the countless policy issues that are going to confront this country in the years and decades ahead. Will courts be able to decide these issues as to things they know nothing about? Courts that are completely disconnected from the policy process, from the political process, and, that just don't have any expertise and experience in an area? Or are people and agencies going to do that? That's what this case is about.
I think the constitutional answer is that Congress needs to set the rules with respect to AI. It can delegate some policy-making discretion to agencies, but once the law is written and the interpretive function has begun, then that job is for the courts. And I think this case actually really is a good example, because I think the problem with Chevron is that, no one really, I'm curious to see what the Solicitor General will say about this, but does anyone really think that Congress was presuming that the agency would get to decide the question of who pays for the monitors?
I have one last question. Do Do you think that Congress could codify Chevron?
I don't think so, because I think that a statute that codifies Chevron would say essentially that the interpretive authority has been reallocated from the court to the agency. I think that interpretive authority—
Congress cannot decide that in cases after all the statutory tools have been used and there remains a gap or an ambiguity, Congress could not decide that it wants people who know something about something to decide the questions that will be left over.
I think that gives away and would take away from courts and give to agencies core judicial interpretive authority. I don't think Congress could do that in the same way that Congress couldn't tell the president how to exercise the veto power or the pardon power. It can't tell courts how to do interpretation and to defer to someone else.
Thank you.
Justice Gorsuch?
Do we have to decide that constitutional question?
I think it makes sense to decide the constitutional question. I think you could.
Do we have to?
I think you could resolve this case under the APA, and we would certainly welcome in an interpretation of the APA that comes out our way, especially if it's informed by constitutional avoidance principles that I think have a lot of salience here.
Is anything in your argument suggest or depend upon the idea that judges should make or decide policy questions about AI or anything else?
No, we 100% agree that judges should not do policy. We just think that they should do law, and Chevron is about legal questions.
Then there was some question about past decisions, and as you pointed out, this court's moved away from using legislative history to some degree in favor of text, and we've made other changes in our interpretive approaches too without Congress's intervention. For example, in the sovereign immunity context, returning to the clear statement rule that had pre-existed this court's jurisprudence for 200 years, and then we wandered off into legislative history and circled back around and corrected our own mistake. We had to deal with the question of what to do with those precedents, and our answer was to leave them alone from those ancient regimes, as we called them. Are you asking us to do anything different when it comes to Chevron?
No, and if I could just explain how I think the world would look with respect to the old cases. I think stare decisis would apply to the holdings of those old cases. I don't think that anything would change. You know, stationary source would still mean what it meant when the court issued that bottom line interpretation. And so I don't think that this would, a ruling in favor of our side would require or entail overturning any of those old cases. I think what we really care about is prospectively, both with respect to the fishing regulation here, but also with respect to other cases that come forward to the courts, making sure that courts are the ones doing the interpreting and not agencies.
Thank you.
Justice Kavanaugh?
Several questions. First of all, on Skidmore, there was reference to Skidmore deference, and I guess I don't think that's the right term, that it's respect or pay attention to, but I think if we throw the term deference into Skidmore deference, we're going to walk into another problem like the one we have with Chevron deference.
Some might say deference is ambiguous. I think that it's imprecise. I think the better way, I think oftentimes when people say deference, what they mean is that if you think the answer is X, you should defer to someone else's answer, which is different. I think absolutely that would be inappropriate. So I would not use Skidmore deference because I think it runs the risk of giving that implication. I think that really we're talking about very serious consideration of the points that the agency makes, but ultimately you have to be persuaded. And if you're persuaded, then that means that you've concluded that the agency has the best interpretation, and then you just apply the normal rules.
Right. I thought Skidmore was about the power to persuade, not the power to control.
Exactly. Yeah. I agree with that.
Okay. On the constitutional issue that Justice Gorsuch and Justice Kagan were raising, you have lots of arguments here, and Mr. Clement does too, for overruling Chevron without reaching the constitutional issue. So I guess why would we reach it if we agreed with you on overruling Chevron on other grounds? I don't see the need to address the hypothetical that Justice Kagan raised about Congress passing a Chevron-type regime.
I think three things on that. Like I said earlier, we would certainly welcome overruling Chevron, especially under the APA and especially if informed by constitutional avoidance principles. But I think there are three reasons why you should consider going beyond that to the constitutional holding. There are going to be some cases that as a technical matter, Section 706 of the APA doesn't apply. And so if it's an APA holding, it may be that in those cases there might be lingering uncertainty about whether deference should apply to cases that aren't technically under Section 706. I think the second thing is that a lot of the analysis in figuring out what the duty under the APA to interpret the law, I think a lot of that analysis really overlaps with the constitutional points. And I think if you get to a place where you agree with us on the APA, it's not that far, not that different to ultimately agree with us on the Constitution as well. And then finally, I would just say that although, of course, this Court often prefers to rule on non-constitutional grounds, I think it's also recognized in cases like Pearson versus Callahan that there's going to be a value and a benefit to the judicial system to providing clarity about what the Constitution means. I think I would respectfully submit this is one of those situations.
On the question of how much does Chevron matter on the ground, I think you addressed this a little bit by citing Judge Silberman, but do you want to elaborate on that? I mean, there are cases, I assume, that get to Chevron Step 2 pretty regularly.
Very regularly, Your Honor. It happens all the time. And I think if a case like this one, or two cases like these two, can get to Chevron Step 2, I think that suggests that it's really hard to figure out how Chevron Step 1 is supposed to work. I mean, the Digital Realty case is another great example. That's a case where there was a statutory definition of the term whistleblower that required the person to have gone to the SEC and submitted a complaint. And the government and the lower court concluded that that was ambiguous and that it might actually apply. It was reasonable to read the statute to not require a report to the SEC. So I think there are cases, there are examples like these that come up all the time. And, thankfully this court doesn't have to intervene every single time. But the reason that the problem is there is because you've told lower courts how to do their interpretation. And as long as that instruction is out there, there are going to be a lot of cases that get it wrong, and you're not going to want to be in the business of sort of error correction on each one.
On the question of how Congress can operate without Chevron, I just want to have you elaborate on that a little more. My understanding is Congress oftentimes will use terms like the agency can regulate reasonable limits or appropriate limits. And that gives, under State Farm, a lot of discretion to the agency to make choices to do what Justice Kagan was talking about, to think about the world as it exists 5 years from now or 10 years from now, and not have to worry about going back to Congress. So the question really is for Congress in its drafting choices, I think, what kinds of broad, capacious terms it uses as opposed to using more defined terms or statutory usual kinds of statutory language. Yes, it can't rewrite that. At least that's how I thought Congress could operate in a world where Chevron does not exist.
I think that's exactly right, Justice Kavanaugh. And I think that, like I said earlier, in those situations, the court's job is basically figuring out what the best interpretation of that word is. And in many cases, maybe most cases, those types of capacious words are basically the best understanding of those words is that Congress is, in fact, conferring the discretion on the agency. And that's very different from Chevron, where instead of having any sort of language like that or express language conferring a delegation, you're basically applying this fictional implied delegation that is triggered by ambiguity, which is like, frankly, it's fictional, it's made up. And so I think a world in which Congress, when it wants to delegate to agencies, needs to be expressed and use language like that or other language, I think is a better world from the perspective of Article 1 and from Article 3.
Thank you.
Justice Barrett?
Mr. Martinez, I want to return to the question that Justice Sotomayor raised about stare decisis. So you said that overruling Chevron wouldn't have an effect on the many cases that have gotten to Chevron Step 2 and then deferred to the agency. You said, did I understand you correctly?
Those bottom line holdings would be right, yeah.
Okay, but the bottom line holdings in those cases, if the court did defer at Step 2, are simply that the agency's interpretation was reasonable. And maybe sometimes, like in Brand X, they might even be like, well, we would reach a different interpretation if it were our call, but it's ambiguous, so the agency can decide. So maybe nothing happens immediately to those cases, but isn't the door then open for litigants to come back and say, well, stationary source really means X, or, broadband, or whatever the specific term was in Brand X. So isn't it inviting a flood of litigation, even if for the moment those holdings stay intact?
So I would say the bottom line holdings in those cases, I would just quibble slightly. I would describe the bottom line holdings as being that the agency's action was lawful. And so that's the bottom line. I think it's true that people could come and say, look, the interpretive methods have changed since this bottom line holding was issued, and we think that a different result now should apply, and that's why courts consider requests to overturn precedent. But I just think that they would apply the same standards that they would apply to other stare decisis inquiries, and I think it would be the rare case that would require that where a court would say this decision not only isn't the best interpretation, but it's like so bad and so practically important that we're going to overturn our own precedent. So I think that would be the safeguard.
So when you say that the bottom line holding, so you've kind of changed the level of generality, right? If you say the bottom line holding is that the agency's interpretation is lawful, you think it's not open to people to come back then and say, well, it's actually not lawful, this is wrong, the court got it wrong because the best interpretation isn't the agency's.
I think litigants could make that argument, but I think they would have to overcome the normal stare decisis test, which is very hard to overcome. And so they would probably have to show that it's really wrong and really practically important. And I think most courts, and I imagine this court, is going to find that threshold is met like almost very rarely, maybe almost never. And so as a practical matter, you're not going to be upending, those bottom line decisions,
Okay.
even if you let people in theory come and challenge them.
So let me
which they
ask
can do now.
you just referred to the, serious stare decisis threshold, that would have to be overcome. So let's talk about the stare decisis threshold here. Why is it different here than it was in Kaiser? In Kaiser, the court declined to overrule Auer, and the part of the opinion that was for a majority of the court was largely, it was on stare decisis grounds. So why would a different result obtain here?
I think my first answer is that the Chief Justice's opinion suggested it might be different, and I think the reasons why it really is different is because there are important differences between Chevron and Auer. The most important that I think plays on the reliance question is this idea that Chevron allows, and almost like a feature of Chevron, not a bug, is that it encourages and allows agencies to flip-flop. And so the reliance consideration with respect to Chevron is much weaker for the government side, because the agency is allowed to flip-flop all at once, whereas with Auer deference, the idea is that the agency, it's going to be very hard for the agency to flip-flop. So I think it's more important to correct Chevron because it has that mistake that Auer doesn't. There are other differences. Chevron is problematic because it lets agencies say what Congress intended or what Congress's meaning was, as opposed to just saying what they themselves meant with the regulation that they themselves enacted. So I think the kind of, the deference makes more sense when you're deferring to the entity that actually created the provision in question, as opposed to deferring to their interpretation of a provision that was created by Congress. I think, in addition, Chevron is not limited to agency expertise. Auer is limited to agency expertise, so Auer is narrower. And then finally, I do think there's a difference even with respect to the APA, where I think the APA more clearly puts constitutional interpretation and statutory interpretation on equal footing, and that might play into the analysis. This court, the plurality in Kaiser sort of emphasized that the APA was enacted a year after Seminole Rock, and so maybe that was a basis to think that Congress was okay with something that looked like Auer deference. But that's not true here. Chevron came many years after the APA. So I think there are a lot of differences that really flesh out, I think, the important point that the Chief Justice was making, which is that the analysis there doesn't automatically transfer over to Chevron.
Thanks.
Justice Jackson?
So I've heard you say several times that you agree that judges should not be doing policy, they should be doing law. And I guess I, too, agree with that. And my concern is that it's actually not as easy as it seems to distinguish between the two. And that it appears in a lot of your answers that you sort of say, well, you come up with the best answer, it's a legal question, but I'm not so sure it's a legal question, as opposed to is it the best under the sort of policy